Throughout history, a handful of cases stunned entire nations, not because of the crimes, but because of who stood in the courtroom. Children, teenagers, defendants so young that today their trials would be impossible. Yet in different eras, under harsh laws and flawed systems, these youths were sentenced to death. This documentary uncovers the real events, the court records, and the decisions that shaped some of the youngest death row cases in human history, and how they forced the world to rethink justice itself. Before we begin, tap like, drop a comment, and subscribe. Your support helps us continue bringing powerful, factual documentaries to the channel. Now let's step inside. Long before modern juvenile justice existed, the courtroom was a place where age offered no protection. In the early 1900s, many legal systems around the world had no separate category for minors, no psychologist evaluating a child's understanding of consequences, and no requirement for defense attorneys trained in juvenile law. A young defendant could walk into a courtroom and be judged exactly like an adult. Same charges, same procedures, and in rare but shocking cases, the same final sentence. Chapter 1 introduces the historical landscape that allowed these outcomes. Newspapers of the era often described youthful suspects with dramatic language, shaping public opinion before trials even began. Courts moved quickly, and juries were influenced by fear, local pressure, or the belief that harsh punishments protected the community. In many places, especially in the American South during the early 20th century, racial inequality, limited access to lawyers, and deeply flawed investigations played an undeniable role. At the center of this chapter is the unsettling reality that some teenagers, and in a few historical cases, defendants barely entering adolescence, were placed on the same legal path as the most dangerous adult offenders. Their age was mentioned, but seldom weighed. Judges believed punishment deterred future crimes. Prosecutors argued that severity showed strength. And in a time before the Supreme Court ruled that children cannot fully comprehend long-term consequences, the law treated youth as simply small adults. But the world did not stay silent. Some of these cases sparked protests, editorials, petitions, and intervention by civil rights organizations and church groups. The harshness of the sentences forced the public to confront a difficult question. Can a child truly possess the same criminal responsibility as a grown adult? These early cases planted the first seeds of reform, seeds that would eventually grow into modern juvenile protections, psychological evaluations, and global bans on executing minors. Chapter 1 sets the stage not with sensational details, but with context. A justice system still learning, societies under pressure, and the tragic misalignment between youth and adult punishment. It marks the beginning of a long and painful journey toward the laws we know today, laws built from the lessons left behind by the youngest defendants who once faced the harshest fate imaginable. As the 20th century progressed, courts began facing an uncomfortable truth. The justice system had no consistent way to handle young defendants. Chapter 2 explores how individual cases, some well-documented, others nearly forgotten, forced judges, lawyers, and entire communities to confront questions they had never truly answered. In many states, the legal age of responsibility was vague. A 14-year-old could be tried as an adult if a judge believed they understood right from wrong. That phrase became one of the most debated standards in criminal law. Psychologists later argued that understanding rules is not the same as understanding lifelong consequences, but at the time, few courts called experts, and even fewer listened when they did. Some trials lasted only a few hours. Defense attorneys were sometimes inexperienced, underprepared, or given almost no time to investigate. Public pressure influenced outcomes. Citizens demanded quick resolutions, especially in small towns where fear and rumor traveled faster than facts. Headlines labeled young defendants in ways that would be unthinkable today, shaping the narrative before the first witness even entered the courtroom. This chapter highlights how these trials revealed deeper problems within the justice system. Racial disparities that affected sentencing outcomes. Limited appeals for minors tried as adults. Lack of standardized legal protections. inconsistent jury instructions about juvenile responsibility, local politics influencing courtroom decisions. Some teenagers received sentences that modern courts would immediately overturn. Others were not fully aware of the penalties they faced until after the verdict was read. Yet, even within these harsh realities, moments of resistance emerged. Journalists raised questions. Clergy members pleaded for mercy. Civil rights groups documented procedural failures. In some cases, governors reviewed clemency petitions after learning the defendant's age. Chapter 2 shows the system at its most conflicted, caught between maintaining authority and acknowledging that youth changes everything. These trials expose the weaknesses in a structure built for adults and force the public to confront a difficult question. If the law treats a child like an adult, does justice truly remain just? The outcomes of these cases would echo through courtrooms for decades, laying the groundwork for appeals, legislative reforms, and the eventual recognition that children require a fundamentally different approach to justice. These early courtroom battles became the foundation of a legal transformation that was still decades away. As more cases involving young defendants reached the public, something unexpected began to happen. Ordinary citizens, journalists, teachers, and community leaders started questioning the very foundations of the justice system. Chapter 3 examines the rise of public outcry, how society slowly began to challenge the idea that children could be treated the same as adults in the harshest courts. For the first time, newspapers published editorials arguing that age should matter. Writers described the defendants not only as accused individuals, but as young people shaped by poverty, racial injustice, unstable homes, or limited access to education. Ministers preached sermons about redemption. Youth advocacy groups demanded fair treatment, and even some prosecutors admitted privately that the system needed clearer guidance. These cases also began attracting national attention. Reporters traveled to small towns to interview families, review trial transcripts, and document inconsistencies. Some discovered that confessions had been taken without parents or lawyers present. Others revealed that juries were not allowed to consider age as a mitigating factor. The more the public learned, the more pressure built on state governments to re-examine how minors were handled in court. Community protests grew. In some places, thousands of signatures were collected in just days, urging governors to grant clemency or reopen investigations. National organizations, including early civil rights groups, took interest, offering support, legal advice, and public visibility. These efforts did not always change outcomes, but they shifted the national conversation. People began to understand that the question was not simply guilt or innocence, but whether the punishment fit the age and mental development of the accused. At the same time, early psychological research was emerging. Experts argued that adolescent brains respond differently to stress, fear, and authority. They noted that minors are more likely to comply with demands, misunderstand legal rights, or impulsively agree to statements without grasping the long-term consequences. These findings didn't instantly reshape courtrooms, but they added scientific weight to the growing call for reform. Chapter 3 captures this turning point, a moment when public awareness collided with scientific insight, creating the first nationwide debate about juvenile justice. It was no longer just about isolated cases. It became a question of national values. Should a society committed to fairness treat young defendants exactly like adults? Or should age, development, and vulnerability demand a different path? This shift in public opinion marked the beginning of a long journey toward change. The pressure created in this era would later fuel major court rulings, legislative reforms, and the eventual end of death sentences for minors. The world was starting to listen, and the justice system could never go back to what it once was. By the mid to late 20th century, the pressure created by journalists, civil rights groups, and public protests had become impossible for lawmakers and courts to ignore. Chapter 4 explores the moment when the justice system began to confront the uncomfortable reality that the harshest penalties ever imposed on young defendants were not simply controversial. They were legally unsustainable. Across the United States, appeals courts started reviewing past cases with new eyes. Lawyers argued that minors lacked the maturity, judgment, and emotional stability required to navigate complex police interrogations or high-pressure trials. Judges began questioning whether teenagers truly understood plea deals, jury decisions, or the concept of irreversible punishment. Little by little, state legislatures revised their laws. Some states raised the minimum age for adult prosecution. Others required special hearings to determine whether a minor could be tried as an adult. For the first time, courts openly discussed developmental science in their opinions, acknowledging that children and adults do not process fear, stress, or long-term consequences in the same way. International pressure also played a role. Many countries had already banned death sentences for minors, pointing to international human rights standards and treaties adopted after World War II. As the global community moved toward recognizing juvenile rights, the United States faced growing criticism for having some of the harshest sentencing policies involving minors. Key Supreme Court decisions further accelerated the shift. Although these rulings came decades apart, together they created a new foundation for juvenile justice. Minors cannot be sentenced to death. Minors must be evaluated differently in sentencing. Youth and developmental factors must be considered by courts. These principles did not emerge from a single case. They evolved from decades of injustice, public pressure, and legal battles sparked by the very cases this documentary examines. Each ruling was not just a legal decision, but a recognition of a broader truth, that childhood and adulthood cannot be treated the same inside a courtroom. This chapter also highlights how advocacy groups began tracking juvenile cases nationwide, forming networks of lawyers, psychologists, and researchers committed to preventing minors from facing extreme sentences. Their work exposed systemic flaws, underfunded defense teams, biased jury selection, inconsistent forensic methods, and a lack of specialized procedures for interviewing youth. Chapter 4 marks the beginning of a legal revolution. What started as scattered courtroom protests turned into a nationwide rethinking of juvenile justice. Laws changed, standards rose, and slowly, the harshest penalties once imposed on some of the youngest defendants in history disappeared from modern legal codes. Yet the story doesn't end here. The cases that inspired these transformations continue to echo through textbooks, legal debates, and public memory. Their legacy forced a system built for adults to finally recognize the fundamental truth that guided the reforms. Children are different, and justice must reflect that. Even as laws evolved and courts began revisiting the treatment of minors, the stories of the youngest defendants did not fade away. Instead, they became powerful examples, case studies used by activists, lawyers, and lawmakers to prove why reform was urgently needed. Chapter 5 examines how specific historical cases shaped national consciousness and pushed governments toward permanent change. Each case revealed a different flaw in the system. Some highlighted rushed investigations, where young defendants were questioned without proper guidance. Others exposed courtroom procedures that failed to consider age, emotional development, or the pressure a child feels when surrounded by police, lawyers, and judges. In many situations, legal representation was limited or inexperienced, creating a battlefield where a minor stood almost entirely alone. As researchers began documenting these stories, patterns emerged. Many of the youngest defendants came from communities facing poverty, racial discrimination, or limited access to education. Their vulnerabilities were often misunderstood as guilt, and their inability to defend themselves was interpreted as indifference. These misunderstandings fueled sentences that shocked later generations once the full context was revealed. Civil rights historians played an essential role during this period. They uncovered archived transcripts, letters, appeals, and forgotten legal briefs that painted a clearer picture of how these trials unfolded. Their work illustrated that the issue was larger than individual cases. It was rooted in systemic inequality and outdated laws that treated all defendants the same, regardless of age or circumstance. Inside universities, law students studied these cases as examples of what not to repeat. Professors used them to teach due process, fairness, and the unique psychology of youth. Researchers analyzed how misinformation, fear, and public emotion influence certain verdicts. Gradually, these academic efforts created a deeper cultural understanding. When children face adult-level punishment, the entire justice system must be questioned. At the policy level, state and federal leaders began recognizing that the reputational cost of ignoring these injustices was growing. International organizations reference these cases when assessing human rights standards. Governors and lawmakers acknowledged that historical errors needed to be addressed, prompting new guidelines for interrogating minors, new sentencing protections, and new rules requiring trained juvenile defenders. Chapter 5 shows the enduring impact of these stories. They became catalysts, not because the outcomes could be undone, but because their legacy insisted on reflection, accountability, and change. Their influence extended far beyond a courtroom. It reached schools, universities, advocacy groups, legislative halls, and global human rights discussions. This chapter serves as a reminder that the youngest death row cases were not merely tragic footnotes in history. They were powerful forces that reshaped national values. Their stories ensured that the mistakes of the past would inform the protections of the future, proving that justice evolves through the courage to face its darkest chapters. By the time the last major court decisions were handed down, the world had already begun to understand something that earlier generations had overlooked. Childhood is not just an age. It is a developing stage of life, shaped by environment, pressure, and vulnerability. Chapter 6 brings the documentary full circle by examining how the youngest death row cases left behind a legacy far larger than any individual trial. Their experiences forced modern societies to face profound questions about fairness, responsibility, and the meaning of justice. In the decades following the legal reforms, juvenile justice systems underwent dramatic transformation. Courtrooms began adopting specialized procedures for minors, trained interrogators, mandatory legal counsel, psychological evaluations, and rules requiring judges to consider age at every major step. Where once a child could be placed on the same legal path as an adult, new standards require courts to slow down, evaluate carefully, and approach each case with an understanding of youth development. Schools, universities, advocacy groups, and legal institutions all became part of this movement. Researchers continued studying adolescent decision-making, revealing that young people are more impulsive, more easily influenced, and less capable of long-term planning than adults. These findings did not excuse wrongdoing, but they reshaped how accountability is measured. The justice system no longer asked only, "What happened?" but also, "Who was this young person at that moment in their life?" Internationally, the shift spread as well. Countries updated their laws to align with human rights standards, making it clear that minors should never face the harshest penalties. These changes did not erase the past, but they acknowledged it, a global recognition that justice must evolve as understanding deepens. What remains most powerful about these stories is not the tragedy, but the transformation they created. The youngest death row cases became symbols of a justice system learning from its own history. Their experiences inspired generations of lawmakers, attorneys, and social workers who believe that fairness must always come before speed, and that protection must always accompany punishment when children are involved. Chapter 6 reveals a justice system that is still imperfect, but far more aware. It shows how the past shaped today's principles. Minors must be treated differently in law. Sentences must consider development, vulnerability, and potential for change. Youth justice must prioritize rehabilitation over irreversible outcomes. As the documentary closes, we are left with a final realization. The youngest defendants in history, many of whom never lived to see the reforms they inspired, changed the world in ways they could never have imagined. Their stories continue to echo across courtrooms, classrooms, and legal debates, reminders of why justice must evolve and why society must never forget the cost of its past decisions. Their legacy is not written in punishment, but in progress. And that progress defines the protections every young person receives today. The stories in this documentary are not just about the past. They are reminders of how far justice has come and how far it still has to go. The youngest defendants in history never imagined their cases would shape laws, influence courts, and force nations to confront the meaning of fairness. Yet their experiences became turning points, pushing the world towards stronger protections for minors and a deeper understanding of childhood itself. Today, no modern court can ignore age, development, or vulnerability because their stories made sure of it. Thank you for watching. If you found this documentary meaningful, make sure to like, share, and subscribe. Your support helps us continue exploring the hidden truths, forgotten cases, and real histories that shaped the justice systems we know today.